What are some defenses in domestic violence cases? Is self-defense a viable defense? The attorneys at Oliverson and Huss Law explain. Self-defense is a viable defense, but it really depends on the facts or circumstances of each case because it's a defense that requires the defendant to prove that self-defense was necessary at that point. It all depends on the facts, the circumstances, and the evidence available to determine whether or not that will work in court. Other defenses include looking into the alleged victim, their history of either dishonesty or false accusations, and whether there's a lack of physical evidence. If it's just a he said, she said type case, then the state may not be able to prove the case beyond a reasonable doubt. Oftentimes in domestic violence cases, the parties get back together after the arrest, and the alleged victim no longer wants to testify or cooperate with the state. That can definitely be used by the defense to get a favorable result. We look at every possible avenue to determine what the best defenses are and what we can do so that our clients don't get that domestic violence conviction. If they get that conviction, not only is there mandatory counseling and the stigma of having a criminal conviction on your record, but at that point, a federal law called Grady Law also kicks in. Under the Grady Law, anyone with a domestic violence conviction is not allowed to possess a firearm. You lose your Second Amendment rights. If you or a loved one faces serious criminal charges, contact us immediately. The attorneys at Oliverson and Huss Law will handle everything from routine paperwork to cross-examining witnesses in the courtroom.